I will go ahead and get us started with today's Center for Business Law event, Considering M&A, Advice and Recommendations from Practicing Lawyers. I'll give some brief introductions for our three panels today. So starting off, Sabrina Chang is a corporate and securities lawyer in Fasken's Vancouver office. Her experience includes working with clients on mergers and acquisitions, debt and equity financings, and corporate reorganizations. She provides strategic counsel to both public and private companies across a range of industries, including technology, financial services, mining, and psychedelics. Reina Mistry is a corporate and commercial associate in Fasken's Vancouver office, providing strategic counsel to companies in the technology sector on a range of issues, from inception of the business to the growth and procurement phases. She assists with startup and incorporation issues, debt and equity, angel and venture capital financings, mergers and acquisitions, and IT licensing and development. And Paul Blyschak on the screen focuses on mergers and acquisitions, private equity, and corporate governance. He is in the Calgary office of Fasken, where he's zooming into us. He is a thought leader in the area of Canadian corporate law and advises clients regarding both transactional and litigation matters. Paul is the editor-in-chief of Private M&A in Canada, Transactions and Litigation, the country's first and only comprehensive book on private M&A, published by LexisNexis Canada. Paul also regularly publishes regarding M&A, private equity, and corporate governance with The M&A Lawyer, the ABA's M&A Deal Points, Lexpert, and the Globe and Mail. He is the author of 15 law journals and law review articles, including with the McGill Law Journal, the Alberta Business Law Review, the Banking and Finance Law Review, the Journal of International Arbitration, and the Virginia Law and Business Review. So before we get started with today's presentation, I do want to emphasize and give a special plug to Paul's book, Private M&A in Canada, Transactions Litigation, because I authored the foreword. So I was involved in that project as well. So it's a great book. I recommend it. Great foreword. So what our panelists are going to be talking about is we have a range of kind of experience from the more junior level to the more senior level, and our three panelists, each from Fasken's, are going to be answering a series of questions to help law students understand what M&A practice entails. I, in my practice career, was an M&A lawyer as well, so I might chime in with some thoughts as well. So why don't we start off with our first question for the panel. At the highest level, what is M&A? What does M&A mean?
Would you like, Sabrina or Reina, would you like to start, or would you like me to go?
Okay. You guys can answer in any order you want. Or maybe I can call on people if that's easier. Go into professor mode. Paul, can you hear us?
I can hear you, Camden. I can't hear Reina or Sabrina.
Oh, you know what? The mic might not. Do you guys have the mic on?
Oh, yeah, we do. Sorry, Paul. What we had said, which I realize that you could not hear now, is we had initially said you wrote the book. Would you like to get us started on it? And then we can augment as we need.
Sure. Yeah. No. Okay. Yeah. Great. I mean, at the highest level, the thing to understand about M&A is really M&A is when one company buys another company. And just to take some, I think the easiest way to talk about that is to just grab some examples from the headlines. And that's one of the cool things about being an M&A lawyer is you often read about the deals that you're working on in the newspaper and in the press, or see them talked about on TV, because one company buying another company is often a very, very large transaction and catches a lot of attention. So one example that we just saw in the news this week was Bell Canada buying from the British Columbia Investment Corporation and other pension funds Zippy, which is a internet provider in the Pacific Northwest in Washington, in states like states like Washington, Utah, Montana, and Oregon. Another one that's in the press right now that's getting a lot of attention internationally is Couche-Tard, which is the Quebec dépanneur chain, is actually trying to buy 7-Eleven, which is a Japanese-owned. It turns out 7-Eleven is owned by a Japanese company, and they're trying to buy that for about $50 billion. And that's a really complicated deal because of the international dimensions and the competition concerns and all the regulatory hurdles that have to be cleared, because Japan doesn't exactly want that to happen, potentially. And if you're sports fans, an example from earlier this summer is when Rogers bought out Bell Canada's stake in MLSE, which is Maple Leaf Sports and Entertainment, which is the company that owns the Raptors and the Blue Jays and the Maple Leafs. So you often hear about these deals. They don't necessarily use the term M&A, but M&A is when one company is buying another company or part of another company, like we saw with MLSE, because Bell only owned about 37.5%, and Rogers owned already that much, and then was buying out Bell. But yeah, so at its heart, that's what M&A is when one company buys another company, and needless to say, that's a pretty complicated thing. And that's why lots of lawyers are involved. And that's why Camden was an M&A lawyer. And so many people who find their way into corporate law actually become M&A lawyers. And that's just one of the things we're kind of going to explore a lot more today, how M&A is basically, if you're thinking about joining a corporate law firm, there's a pretty good chance at least some of your practice is going to involve M&A. And that's something that we'll kind of flush out as we have this discussion today.
Yeah, no, I totally agree with you 100%. I think that's a fantastic description of it. At the core of it, it is really just about like one company acquiring another and like having a company, and it doesn't even have to be necessarily 100%. It can be sometimes just the change of control of the company. It's really about just the transfer of control from one company to the other.
Yeah. From a junior perspective, I think it's been really cool seeing the different types of transaction structures. I've worked on a few M&A deals since starting out at Fasken. I've been associate for 2 years now, and none of them have been the same. So M&A it can be pretty complex, the types of deals we see come across our plate.
Yeah, I'd probably say that's the fun aspect of it, in terms of like, even though it sounds really at the high level, it is really basic. It's just like one company buying another, but how the sale actually occurs, what are you buying, how is it structured, all those kind of nuances and complexities are what really kind of make it interesting. Those are the nitty gritties, and we'll get more into that, I think, as we go. But that's sort of the fun part.
Okay, that kind of leads to our next question. And before I ask that, I would just mention that M&A, the term, it stands for mergers and acquisitions. That's what it means. And I always point out to my students, ironically, there is no such thing as a merger under Canadian law. So it's a term that is borrowed from U.S. practice, where a merger is a statutory mechanism for acquiring a company. And in Canada, there's other different legal mechanisms. But that leads to the next question involving M&A practice. So do most corporate law firms have dedicated M&A groups?
Yeah, I'll go first again. I think the short answer is yes. Certainly when you're talking about the firms, the big firms that we all know in Canada, like the Faskens and the McCarthys and the Blakes and the Oslers. I mean, any corporate law firm you've heard of has most certainly has an M&A group, and it's a very good chance it's one of the largest, if not the largest, groups at the firm. Again, for all the reasons we've discussed, because these deals take so many lawyers. So even the smaller shops, like Lawson Lindell, which is a big firm still. I'm sure the M&A Group is one of their largest there. And then even down to smaller corporate firms, they're all going to practice M&A to some degree. The big difference is the size of the transaction. The bigger corporate firms will deal with the larger transactions. But even if you find your way to a firm that's only 10 or 20 lawyers and is just like a small local firm, they're going to have business clients, and there's a very good chance that they will occasionally do the smaller size deals because their clients are either going to be purchased or purchase a small competitor, or it's not always buying the entirety of a company. Sometimes you're just buying a division or part of a company, and so it's not necessarily a share deal, but an asset deal. But yeah, in the highest terms, certainly every corporate law firm has an M&A group, and they're very often the largest. So at Fasken, for example, the CMMA group, which is the Capital Markets and Mergers and Acquisitions group, is the firm's largest group. And as you might take from the name of the group, Capital Markets and Mergers and Acquisitions, literally half of what we do is M&A. The capital market side means raising money for corporations because corporations need to raise money to do things. And then often you do both. You help them raise money in the public markets or otherwise, and then you help them spend that money by buying the company. So long story short, it's pretty integral to corporate law firms. Certainly all the big ones. And then even as you go down into the smaller corporate firms, it's not so much a question of whether they'll have an M&A group, it's how often they do M&A, or how important M&A is to their practice.
Want me to go first?
No,
or you
you
want-
can go ahead, yeah.
So I think just to add to your response, I think sometimes you might actually see the groups being called like the mergers and acquisition group, just like Paul just referenced. Other times they might not actually be called that. It might be a group of people within the corporate commercial group or within another similarly named group or within industry groups as well. So regardless of that, usually if you are a corporate lawyer, you will have to deal with some M&A at some point in time. It's quite often that, so for example, like I'm not technically part of the CCMA group, but I am because I'm part of the technology group, but I deal with M&A regularly because our companies are often being acquired and sometimes doing the acquiring. So it does, just to say, like, it's not always guised under the group name of M&A, but they are around. With respect to smaller firms, they also do it. But like Paul said, it is oftentimes a simpler transaction, like oftentimes smaller in terms of size or simpler in terms of like less complex. Sometimes you'll have companies that are with a smaller firm for their corporate needs, and then and then when it comes time for them to be acquired, they might go to a different firm, like a bigger firm, because of the expertise that a bigger firm might have in terms of the experience that they have from doing larger complex deals. And they might go specifically to a larger firm just to get that appropriate counsel, because the transaction that they're contemplating might be more complex or might be more challenging for the smaller firm to do. So even though there are lots of M&A lawyers and you'll see lots of different firms that do M&A, the experiences that those lawyers may have will differ according to both the type of firm that they're at in terms of the type of experiences that they're exposed to, as well as like their industry groups.
So for me, the type of M&A transactions that I've been exposed to the most have been the public M&A deals, because I'm in our securities group. I think nationally it's branded as the capital markets group. And the process that we have to go through is oftentimes very different. Speaking to some of the private M&A lawyers, they're like, I don't know how to deal with exchanges and the documents that we have to prepare. The timelines are quite different as well. So I've been just recently starting to get more on the private M&A side. So I think as a junior, it's nice to see those types of transactions through. But yeah, the steps involved are quite intricate.
Yeah, I think you hit on a really good point there. I think it really gets to the idea of the differences in experiences in terms of really depends on the companies that you're working with, and both this complexity of the transactions, but also that the types of companies that you're working with can lend itself to the complexity of the transaction in terms of like a public company will have different requirements in terms of regulatory requirements that working with private companies you wouldn't necessarily have to deal with. So for example, my practice is primarily private companies, so I don't have to deal with as much of like the security regulations and such that Sabrina has to deal with in hers.
Yeah, great. And I guess I was just maybe chime in with my own personal experience. So I worked at a large law firm in the United States. And at that particular firm, it was a bit unusual in that there was nominally there were only two practice groups. There was litigation and corporate. Those were like literally the only two practice groups. But of course, people had practices that were quite specialized, right? So the M&A practice within the corporate group, it was the biggest practice at the firm, and it was the profit center of the firm. It remains the profit center of the firm. I think that's true at a lot of large law firms. One thing I'd also mention is, M&A involves a lot of work, it involves a lot of lawyers. It's generally a large practice area. It's often a very profitable practice area, but it's also a very cyclical practice area. And so, when times are good, there's a lot of work to be done in M&A, and when times are less good, M&A can be very slow. So the practice can be very affected by the business cycle. Great. Now I'd like to ask you kind of a question about your personal practices. So for the three of you, maybe you could just kind of go through and describe, because all three of you have somewhat different practices. What portion of your day-to-day practice is M&A? And you can go in any order you want.
It's not too much M&A right now. I'd say I'm on one pretty big transaction, but there's no real timeline. We're still in the due diligence section of it. So I'm on that one M&A. But other than that, I've been doing a lot of financings, and that's about, 30% of my practice. And then the latter half, I've been doing corporate governance work for financial institutions, which is interesting. But in terms of the hours, it is very cyclical. There's some months where we, don't get too much work at all, and other months where it can be many hours and, sleepless nights. So one thing to prepare as a M&A corporate lawyer is the spontaneity of your work and the lifestyle, because it's hard to predict sometimes, especially as a junior. Sometimes you'll have a transaction that's kicking off on a Monday and you won't know until you get in that morning. So that's something that I'm adapting to, but it's been very fun.
Yeah, I'd say it's definitely a bit of a roller coaster when you're on one. There's definitely ups and downs and highs and lows, and sometimes you'll be speeding along like a zooming train, and sometimes you'll be coming almost to a complete stop, but hopefully not a complete stop. So definitely a bit of a roller coaster when you're on it, and you can't get off, or it's very difficult to get off. But I think Camden's right. Like, it's totally cyclical, because when I look at, for example, during COVID, during the years 2020 to 2022, right? Interest rates were very low. The economy was super booming. So I think M&A was like pretty much what I wrote it down. It was about like 50 to 75% of my practice, because companies were getting acquired one after another after another. I did like deal after deal after deal those years because it was the right time for it. But since then, right, interest rates have come up, money's not as available anymore, the economy has slowed down a bit. So now I would say it probably accords for maybe like 30 to 40% of my practice right now. It's definitely very cyclical, comes and goes. And so that's why oftentimes in Vancouver, you'll see that you're not able to necessarily sustain a practice that's 100% M&A all the time. You'll often have it balanced out with things like financing transactions are oftentimes what I'm doing in the meantime, corporate governance work. You have other sort of specializations that round out your practice, and that also obviously like augment your M&A practice, but it's hard to do M&A 100% of the time in Vancouver just because we don't necessarily have the businesses to be able to support it.
Yeah, I think the thing I'll add, and it builds on a point that Reina made earlier, is M&A isn't always buying the whole part of a company. It can be buying an interest. M&A, private M&A has certainly been the most, has been the majority of my career. But one of the things I like about it is those instances where your client is just buying part of a company or just selling part of a company, kind of like the MLSE organization, which didn't just have one owner. It wasn't BCE and Rogers and the other owners, but multiple owners. So when you have multiple owners, then you need a shareholders agreement between those owners. So a lot of times it's not just the deal doesn't stop with the acquisition or the sale, but often that part of that involves negotiating or renegotiating a shareholders agreement between all the other owners. And it doesn't just have to be for a company. So, for example, I did a lot of work on the LNG projects that are getting built in British Columbia right now. Like LNG Canada, for example, is co-owned by 5 Asian state-owned energy companies, Petronas and PetroChina, and there was a massive joint venture agreement behind that project. Shell started it, and then it sold off interests to various people, and so there has to be an agreement by which all the owners agree. Okay, how are we going to own this thing? How are we going to run it? How are we going to? What's the governance going to be? Like, how many seats does each person have on the board of directors? Who has vetoes on what? So that's really fascinating to me because it's all these people. It's multiple people coming together either to own a company or a business or to own a project. At the end of the day, they're both businesses. And they can be very big things, and it's really cool to bring people together, people who want to do something great together. And it's like, okay, how are we going to build this awesome project together, or how are we going to run this awesome company together? And so there's the transactional side, but then there can also be the we're working together towards the same goal side. And that to me is something I really like to be a part of, because everyone's trying to pull in the same direction at the same time. They kind of want to do things a little bit differently, and you have to find compromise. But that's a really cool part to me about being an M&A lawyer, because then you get to see the results in the real world of the thing that you're helping people do, whether it's this big project that's going to go for 30 or 40 years, or this really interesting sports company, which is just fascinating to watch. Yeah, so that's part of what I love about being an M&A lawyer. It's not just the deals, but the relationship building that goes behind those deals when there's multiple owners of a company or project.
Great, thank you. So I want to make sure that we leave plenty of time for questions at the end. So I'm gonna skip over one of our prepared questions and move on to a question that has to do with how M&A practice intersects with other practice groups. So for the three of you, in the scope of your M&A practice, do you work with other types of lawyers and other practices? And if so, what types of practices?
Shall I go first, or do you want Rena?
I can go first on
Yeah,
this one. So 100%, we use lawyers from across. It's one of the joys of actually being in a big firm, is that you have access to lawyers in all the different groups, because you actually really do need them and rely on them, because you'll be pulling in people from all sorts of areas. So for example, on an M&A transaction, I'll probably regularly call up people in our labor and employment group. I'll talk to people in our IP group. I'll talk to people in our I'll pull in people from tax, definitely tax. Tax is always involved. Sometimes litigation, real estate, if there's land involved, there's always going to be somebody from real estate looking at that agreement and putting in their opinion on it, putting in their 2 cents. There's always going to be subject matter specialists that are going to be required, if only not just for the review of reps and warranties that your company is going to be providing, or that you're requesting from that the target company provide, depending on which side of the transaction that you're on. Sorry, I should have said this at this beginning. So I do primarily sell side with a little bit of some purchaser side, but a lot of mainly sell side, which is different to a lot of the other M&A lawyers. A lot of times, if you're an M&A lawyer and you're at a big firm, you're often doing buy side, just because our clients tend to be smaller because they're smart startups. So oftentimes I'll speak from the sell side perspective of things. So sorry for that default. But generally speaking, yeah, you're pulling in people from all over the firm, because they have knowledge that you guys just don't. And especially as an M&A lawyer, like, I don't know what's going on with real estate. I don't know if there's certain things for land. Environmental is a huge one that's coming up more and more. Data privacy is the other one that like is becoming more and more relevant with cybersecurity issues, data like privacy regulations, the GDPR. Like, you'll see reps in your agreements without this regarding this. Tax, because tax will impact your structuring of your transaction 100%. So tax will always be involved start to finish. So you'll see, like, it's not just like an M&A thing. It's not just a corporate thing. It pulls in people from all over the firm that are providing input on this on documents and on the transaction itself.
Yeah. I think another big one for the tech side is IP. Yeah. IP and privacy. I was on a transaction recently where we literally set up a call just to go over the IP refs. For tech companies. As a junior, oftentimes I'm the one pulling in a lot of the specialists. I'll take the pen on the disclosure schedules or a due diligence memo. And Jeff, one of the partners in Reina's group, he's like, okay, go look through the reps and identify all the specialists that we need to pull in, and then I'll coordinate with them. And then, sometimes they'll send me back notes from the documents that I provided for them to review. And then I'll go ahead and summarize them in our due diligence memo, or sometimes the disclosure schedules if the client wanted us to hold the pen on it. So it's good to have those familiarities and to create relationships with people from the other groups, because I'll often tap in people who I've had great working relationships with and pull them into our transactions.
Yeah, one thing I would just add is, like, it's not just about the documents themselves, it's about the ongoing relationships, like Paul mentioned, in terms of like, what is the ongoing corporation going to look like? If you're just buying a portion, then there might be like employment agreements to be put into place, or you might be consulting with your employment lawyers regarding that. Like, you have to think not only about the transaction itself, but what is going to happen after the transaction. And so you bring in specialists with respect to that as well. Sorry, Paul, you can go.
Yeah, the metaphor I like to use is the M&A lawyer is kind of like the bus driver or the quarterback. Like, the M&A team has the main responsibility for driving the deal forward. But if you're buying another company, you need to know everything about the company that you're buying. You need to know about the situation with their employees. So you bring in the labor and employment people. To Reina's point and Sabrina's point, you need to know if they have any environmental liabilities. You have to know what's going on with the real estate. If it's a big transaction, there's going to be competition issues. You're going to have to get competition approval from the Canadian government. Or if it's a foreign investment transaction coming in, you have to get ICA approval. So the M&A lawyer is the one driving the deal forward, and then you're bringing in all the other specialists to tell you what you need to know about that company and to structure the deal accordingly. Or if the company's being sued, you got to bring the litigators to look like opine on the litigation. Is this a big deal? Like, is this a real potential liability? So you're the one. You're either you're the bus driver analogy. You're getting all the other people in your firm on the bus, and you're kind of steering it forward. Or the quarterback analogy. You're the one calling the shots and saying, hey, I need you on this. I need you on this. So I think M&A lawyers work with more other lawyers in their firm than any other lawyers within the firm. And that's kind of cool, because you're a specialist at M&A, but then you start getting good at picking up these little, you don't have to know everything about it, but you get good at identifying issues, like to Reina's point. Oh, I'm going to need him for this, or I think we might have an issue there. I'm going to call so-and-so. And so that's pretty cool. You get to know everyone in your firm pretty well.
Great. So my next question is, many law students, perhaps naively, associate the practice of law with litigation and with, going to court, arguing in front of a judge, etc. Do M&A lawyers ever go to court?
Sorry. Sometimes I haven't, but for example, on the public side, sometimes they'll do like plan of arrangements, which is a court supervised process. So recently, I was on a transaction where a lawyer in our group went to court, but not to present the case, but more so to just provide the deal specifics if they were called upon. So for plan of arrangement, they'll go to court for the interim order and then also for the final order.
Yeah, so plan of arrangements again are the primary way we see that in the private world as well. We'll sometimes do a plan of arrangement just because we'll often do a plan of arrangement, for example, when there's a lot of shareholders in a company and we can't get approval from every single one of them. Or for example, if some shareholders have died and you just can't track them down, then sometimes you'll go to do a plan of arrangement just because you're not going to be able to get consent from them. So in which case, like Sabrina said, so like we did one at oh my God, it was beginning of January this year. It was like right around Christmas, which Christmas in the courts is always fun because they're shut. So that was an interesting experience. But like you said, like it's like Sabrina said, it's really about like the litigator will be the primary one who's like presents the case, but really as the M&A lawyer, you're the one who's putting it together for them, supporting them through it, and then providing any additional information that they need. Because you're the one that's, again, like Paul said, driving the bus. So you know the most information about the deal.
Yeah, I couldn't have said it better. Nothing to add.
Okay, I might just add that there is no such thing as a plan of arrangement in the United States. It's not a mechanism that exists. So a U.S. M&A lawyer would never go to court for any reason, and just the very thought of it makes my skin crawl. So
The interesting thing there,
I'm with
Ken,
you on that one too. So
the interesting thing there, though, is that the plan of arrangement provisions in our statutes weren't designed for M&A, and they only started getting used like in the late 80s, early 90s, and then it was like this, hey, we can use this thing for
is that
M&A.
so? So they were just used for like debt arrangements before that? Or?
Yeah, that's for primarily for restructurings. That's right. Yeah, that's right.
Interesting. Okay, so sounds like M&A lawyers, they don't spend too much time in court. So what do they do? What kinds of legal work and documents go into an M&A deal?
Yeah, I can tell you the most important one that I think, as a junior, you want to make sure you have a good closing agenda. It's a checklist that sets out all the documents you need. So the great thing about working at the big firm is we have a lot of precedents. So I'll pull a good precedent and then curtail it based on the specifics of the transaction. But, a piece of advice that I got really early on is you want to spend a lot of time on this document to really understand the deal and to make sure that nothing is missed. Now we have this software called closing folders. I don't know if you've heard of it, but before, like you would have a Word document with the closing agenda, which we still do. But now I know a lot of firms are transitioning to this site where you can plug in the closing agenda and then tag all the parties. So oftentimes the other lawyers that are on it, the other firms, and then you can revise it in real time together and then upload different versions of the documents directly on that website. And I've used it for the last few deals I've been on, which is great.
yeah, so I mean, the closing agenda is essential in terms of like it sort of sets out it says out every little sort of document and step that you need to do in order to make the transaction occur and to get the transaction to closing. In terms of legal work, I think one of the key things is the thing that everyone sort of hates, but is so essential as a junior is due diligence. Due diligence is when you're going through and usually it's juniors who are doing this, but sometimes seniors as well, depending on how much needs to get done and it's all hands on deck. But essentially what you're doing is you're looking through the company's records, you're looking like its corporate records, you're looking through its contracts, you're looking through its IP agreements, you're looking through all of the history of the company to see if there's any skeletons or any red flags or anything that the company needs to be, that the buyer needs to be aware of, in terms of things that could either potentially impact the value of the company, or the perceived value of the company, I should say, because oftentimes you don't know, as you may not necessarily know why the purchaser is willing to pay a certain price for the target, for example. So whether it's reputationally or whether it's strategic or whatnot. So what you're doing is you're reviewing to see if there's any red flags, any skeletons, things that need to be brought to the client's attention, and things that need to get fixed. So for example, the company made a bunch of option grants to their employees, but they didn't actually document it because they never do. And so going back and fixing that and making sure you can do that. And if you're in the US, you may not be able to do that. And there are tax ramifications for that. So how does that work for like US employees, if the company has US employees, and trying to get ahead of that? And then, because some of those things may actually substantially impact the deal, whether it's the structure of the deal or the value of the deal, and have to get adjusted for it. So whenever you're doing this, I would just say ask as a junior, when you're starting off, you're like, can you just get told, look for any red flags and like let us know? And you're like, what is a red flag? How do I know what is a red flag? I don't know. I'm not familiar. As you do it more and more, you'll get more experience. You start to see what is a red flag or what's not. But when you're starting out, if I could just give a word of advice, it's just to ask questions. Ask questions. If you don't know something, just ask, because there'll be people with more experience than you looking at it as well. And so you can bring it to their attention and they can look at it harder, or and listen to your gut. Because if your gut is something that telling you that something looks a little bit weird or odd or different, or this seems odd, like there's litigation here, like it's good to know about. So always just bring it to your senior person's attention, like whether it's senior associate or who, and then they can deal with it. But yeah, diligence is one of the big things starting off with, I would say, is like key that juniors will often be doing. Sorry, that was a little bit more directed.
The only thing I'd add is, M&A transactions are big and there's different phases. There's the lead up, the negotiations, and the big part of that is signing the definitive purchase agreement and all the negotiations that go into that. And Reina's mentioned reps and warranties, and Sabrina's mentioned disclosure schedule. So there's this main agreement, but then there's all these other agreements that get appended to it, and all those things are getting drafted and negotiated, and they're getting informed by the due diligence and that investigative work that Reina just mentioned. And then you get signed, and then you enter the interim period, and there's a bunch of stuff that has to get done during the interim period, particularly the regulatory approvals for the big transactions. So your competition people are dealing with the government. And then you're getting things lined up for closing, which is the closing agenda that Sabrina mentioned, and all the things that need to get done there. So lots of different work changes as the deals go, different work in different stages. And then that ties back to what Camden said earlier about how, M&A groups are sort of the engine of corporate law firms, and often the most profitable group within corporate law firms, because there's so much work to do in those different work in different phases. And it just goes back to the earlier point we talked about why M&A groups are so important, because these transactions keep a lot of different people busy over, sometimes significant time periods.
Okay. So, in the room today, we have a lot of law students, mostly law students, I assume. So this is kind of a question on behalf of law students, or from the perspective of law students, perhaps. So kind of focusing on the summer student experience and the articling experience, what is the type of work that summer students and articling students do at M&A? So this is almost like the sub-junior level, I suppose. And how can, like an articling student, for example, prove themselves or distinguish themselves, somebody who's anxious about getting hired back, perhaps, how can they sort of demonstrate their value as a junior person on an M&A deal?
Been closer for me. I think to distinguish yourself and to really impress people on an M&A transaction as a junior is to be there when you're called. Because as a summer, you're only there for a short period of time. It's 4 months. You're probably not going to, be on one transaction that you can see through, because oftentimes transactions can last months, or, I've had one that lasted about a year between sign and close, or actually it didn't close. So you probably won't be on the entire thing. You'll see aspects of it. But when it comes time for closing, oftentimes we'll want to pull students in to help with signature pages, reviewing documents, making sure everything looks good, checking it against the closing agenda, things like that. So when, things start to get really busy, that's when we try to get, as much help as possible. So I remember, when I was in my first few months of articling, I had a closing come up, and it was just all hands on deck. We had, I think, 3 students involved in it. Yeah, that one.
Oh, I remember that one. There are certain transactions that will stick with you after a period of time. You do a bunch of them, and some of them will just like forget about the next week. But then there are others that stick with you, and that was one that sticks with me still. So in terms of student work, yeah, I think Sabrina was totally right. Like, as a summer student, it's harder to get involved in a transaction just because the transactions usually will last longer periods of time. That being said, if you are getting involved, it's probably going to be with diligence, like I just referenced. And reviewing docs, like reviewing director's resolutions, reviewing contracts, things like that, whether it's for change of control provisions to see like what consents are needed, things like that. But you'll do this, and you'll do the same as an articling student. Definitely you'll be involved with due diligence. But also as an articling student, you'll get more involved with drafting some of those like ancillary documents. So these are other like other little documents that are associated with the main transaction documents, but that are a little bit simpler and like 1-pagers or 2-pagers that are easier to prepare just to get you familiar with what's going on. And you'll probably be in charge of like the closing agenda, and which sounds really boring, but it's actually really fantastic, because the closing agenda, like I said, lists out all the steps and all the documents that you need for the transaction. And so it forces you to get familiar with all those steps and what all those documents are. Even if you're not preparing them, at least you get to see what they look like, what did they exist, who has to sign them, you get familiar with that. In terms of being like a good student, I think being engaged is key. Just show that you're interested. Just be engaged in terms of like act interested, be interested, like be legitimately. If you're legitimately interested, just show it. And then because people want to work with people who are interested in what they're doing, and as well as like ask questions, be curious, like even though these transactions they can move at an incredible pace. Like I just did I did one in January, and it was 8 weeks start to finish, which was for the size of the deal and complexity of the deal, quite a lot. It was an intense deal. So you may not think that there's time to ask questions, but do. It's really important to show to ask questions, to learn while you're doing it, to learn through osmosis, and just a lot of it goes to being present. Just by being present, you don't realize how much you learn just by being in the room and just by watching people do things. And that's not just for summer, that's for summering, that's for articling, that's for junioring, it's for your entire legal career. Just by being present and just by watching and listening and being a sponge, just soak it up. You can soak so much up. Sorry.
And to add to that, when lawyers are on transactions, especially the partners, sometimes it's just they're so busy they don't, they forget to pull people in. So just by, as Reina said, being there and then being proactive, if you want to shadow a particular call, some partners will sometimes invite me into their office and be like, okay, you can just sit here while I'm on this call, and just learning through that is great. But being proactive, and, sometimes people don't reach out to you because they genuinely are too busy and they forget. So you can be the one that drives it.
Paul, do you want to add?
Yeah, no, I would just say if you think you're interested in M&A, a good way to show your interest when you're articling, when you're a summer student, what you can do to prepare for that is like we just pointed out some of the deals that are being written about in the Globe and Mail. Read the newspaper, read about the deals that are happening, follow them, or go to the website of Fasken or the other corporate law firms and sign up for the M&A bulletins where we talk about the latest M&A case law that comes out that can influence practice. So, inform yourself with that knowledge so that when you're articling, you're able to ask more questions, you're able to point out things that you've been following. You can say, oh, this sounds like this deal, or is it kind of like that deal? And if you show interest in the area and you show associated knowledge, that'll make people want to go to you more, because it starts to build trust, and it shows that you're invested. It shows that you've taken an interest. And those things are the things that, subconsciously really affect how people view you. And a lawyer, in law, trust is so important. You want to be able to trust the work that someone is doing for you. And if someone has shown you proactively that they have an interest in that area and they're trying to self-educate themselves in that area, then trust is more naturally going to flow and build when you're able to sort of drop those signals. So there's a lot of opportunities to self-educate.
Thank you. So we've talked quite a bit about the practice of M&A, and so now we're going to kind of circle back to a more fundamental and more personal question. But could each of you tell us why you chose to pursue M&A in your own career?
I can go first, I guess, with this one, since I have the mic. So I didn't actively choose M&A, really. I didn't set out and saying, I want to be an M&A lawyer. This is what I want to do for the rest of my life. That wasn't sort of me. So I gravitated towards the tech practice just because I like working with entrepreneurs and small startups and helping them grow and scale their businesses and helping them on their journey. That's just what I like to do. And one of the key aspects oftentimes for those entrepreneurs along that journey is the exiting process, the M&A process. So I sort of fell into it by accident in terms of it's just the natural end result of a lot of the companies and the clients that I work with, is that the clients I work with either want to continue to grow and scale their business, or they want to get acquired by a larger company, ideally so that then they can take that money that they get from that deal and go start another company, or reinvest it into other companies in the community to make those other companies stronger so that they also become M&A targets as well. So I sort of fell into it by accident, but I actually really enjoy it because I think for me, it's I enjoy it because for the founders that I work with, it sort of represents the culmination of their efforts and it helps them realize on their dreams. So that's what drew me to it, which sounds super idealistic, but it's kind of true.
Such a great answer. Similar to Reina, I also fell into M&A. I went to law school out at Ottawa U, and they didn't have many business class offerings. So you're all really lucky here if this is the area that you're wanting to go into. But I signed up for an optional moot in first year, and I was like, oh my God, I'm so bad at this. This is not for me. So when I went out and, got my summer position, I really wanted to try out solicitor work to solidify, okay, this is what I want to do. And, naturally a lot of my mentors came at it there. And on a personal front, my parents had a small business, my partner's a business owner. So I was just surrounded by a lot of people who, have small businesses in my life. And it was fun to understand the other side of it. And just personally, I found it really interesting. And that's how I got into it. Paul?
Yeah, my story's similar, right? I just wanted to do corporate law. I started off as a litigator for the first couple years of my practice, but didn't like that too much. And when I moved to Calgary, made the switch to solicitor side work. And then it was only really just joining the corporate side that I realized how much M&A it is on the corporate side. And so next thing you know, I was on my way to being an M&A lawyer. And like Reina and Sabrina, I never really set out in law school or before that thinking I was going to be a transactional lawyer. It just turns out that once you get into the corporate world, it's a big chunk of what's out there. So I don't think our stories are frankly that unusual. It might be more unusual for people to early on set out to be an M&A lawyer than it is for people to all of a sudden find themselves a couple years out from law school.
So for our final question, our final prepared question at least, somewhat relatedly, what advice would you give to law students who may be interested in learning more about M&A or are considering a career in M&A?
Well, going to presentations like this is great. So you're doing it already. Learning, from having coffee chats with lawyers. I did a lot of that before because what you learn in school, at least my experience at Ottawa, it was very different from what I see in practice. I know you have the corporate externship program here, which I heard is great just to get that hands-on experience while you're in law school. But when, you're in your summers, you're articling, just, asking lawyers to shadow them when you can, being proactive, asking to be on M&A transactions. We get a newsletter. Is it every week? What's Market? Yeah, that tells you, what transactions lawyers in your firm are involved with. So people will, seek out who's involved in the deal and ask, can I be a part of it if it's something they're interested in? So yeah, being proactive and going to presentations. I still go to a lot of presentations myself just to see what's out there, and you're all constantly learning in this practice.
Yeah, I think what you said is literally what I wrote down in terms of like law outside of school is very different to what they teach you within school. And so coming to the presentations, just listening to what people are saying, asking questions and talking to different people and get different experiences. Everyone's experiences, each lawyer's experiences is going to be different. A lot of it will depend on their industry. What kind of companies do they deal with? Different industries will have different needs and expectations with respect to M&A. They'll have different issues that they're facing, issues that are specific to those types of industries. So talk to as many, like if you're really interested in that field, talk to as many people who are in that field as you can to ask them questions, like to tell you about their deals that they're working on, things like that, as much as they can, of course. And then just being like, I think you hit the nail on the head in terms of like, just be proactive, like talk to the people who are like, once you're in a firm, talk to the people who do that type of work within the firm and like see if you can get staff on their deals or like see if they have a deal going or talk to them about previous deals that you did that that they've worked on. For example, most people on the law site websites will have deals that if they've worked on an M&A deal that's public or that's been made public, I should say, not necessarily for public companies, but that has been made public, you can ask them questions about it in terms of, and then they'll tell you what's probably in the press briefing, but they might be able to tell you about like just the experience of it and stuff like that. So just be curious, ask questions.
Yeah, and I'll just repeat what I said earlier. Read about it in the newspapers. Go to firm websites like Fasken. We have a couple of guides on public M&A. We have a couple of guides on private M&A. We just wrote the first book on private M&A. Sign up for bulletins, law firm insights. Read. Lawyers are writing about what's important to their practice area. So read what the labor lawyers are writing. Read what the environmental lawyers are writing. Read what the litigators are writing. They're writing about what matters to their day-to-day practice and see what's most interesting to you. And you'll get a flavor for what they do, and then you'll know a bit more about it for when you land at your summer or at your articles, and you'll be better armed to make a decision as to what direction you want to take your career.
Okay, thank you so much. We have plenty of time for questions in the room, but before we turn it over to the group for questions, why don't we give a round of applause to our presenters for a terrific presentation. And I will now, I guess, just ask if anyone has questions, I guess in the room or online.
So specifically regarding M&A, especially at Fasken, my question is, Sabrina mentioned earlier that there really is a lot of ebb and flow. And so my question is, during that flow, how do you balance that with other life responsibilities like, let's say, family or raising kids? How do you manage to balance that? And it'd be interesting to hear from Sabrina, who's kind of new to, as well as Reina and Paul, who have been doing this for a longer time. Thanks.
That's a great question. It's tough when things start flowing, especially on a transaction closing. There's no way around it. You're working around the clock as a junior. At this point in my life, I don't have kids, but it's definitely something that I want one day. So you need I'm lucky I have a supportive partner who helps me out during that period. Supportive partners also at work who understand, okay, you have this personal thing going on right now, or I can't attend all the meetings, or I need to get my sleep, will cover for you. So having a supportive team, which, prior to joining the group, I really got an understanding of the people that I work for and their, dads, moms, so they understand, and like the balance. But when, you're on a closing, it's really part of the deal. You can't really get out of it. So it's something that I'm working on myself as well. In my group, we actually it's got 3 new moms, and they've been transitioning slowly back into work, and our lawyers have been trying to staff them on deals that aren't as demanding in terms of like the time demands, but still interesting. So I think just working with supportive people who care about you as an individual is important, and I'm lucky to have that.
I mean, it's hard. It really is. And it's going to be different for each person, and it's going to be different for each deal, because each deal has its own, you'll see this when you do more and more deals, you'll find that each deal has its own character, whether it's in terms of timeline or complexity and such like that. And so each will have different demands on you. I used the comparison of a roller coaster earlier, and it really is oftentimes kind of like a roller coaster. I mean, and it is industry dependent. For example, if you look at, like, for example, M&A in a natural resources context, that has a very different time frame and a very different speed than an M&A tech transaction. Our transactions will often be very quick and very short span, but a natural resources M&A transaction can last for years. So it really depends on your industry group. It depends on the transaction. It depends on the complexity of the transaction. But it can be really hard, because there always will come a push and shove time when it gets close to closing, or when you're going to need to have longer hours rather than shorter ones. And so it really comes down to your support in terms of like your community around you, both within your firm in terms of your colleagues, but also like your home support and what other support structures that you have in place. And that's something that's totally personal, and it really just depends on your home situation. And for example, for me, I also don't have kids, but I have friends who do. And you just kind of somehow make it work. You take that time, you structure it in such a way that, you know what, yes, this is all encompassing, but I can take the half an hour that I need to go to put my kid down, or to take the hour to like make my kid breakfast or like dinner or whatever. Like you somehow fit it around and you make it work. It seems like a bit of a cop-out answer saying like you make it work, but you just do, because you have to. I don't know. Maybe Paul can speak to this better than I can.
Well, the main thing I'll add, now that I've been doing this for over 15 years, is that fortunately, I could say 2 things. Is there's been a positive evolution in the industry so far as I've seen from here in Calgary, in terms of more firms appreciating the need for work-life balance, because burnout is just a real thing in the profession, and it's been getting worse. It's not been getting better. So the good news there is that more firms have come around to the realization that they have to do everything within their power to give people time when there is time to be given. And so what I mean by that is, oh, you're not on a deal right now, or like, oh, we're in the bottom of the roller coaster cycle. Like, go home. Like, you don't have to be here. Go home. Go do something. Go on vacation. Like less pressure to be around and just be seen. Like more emphasis on letting people take time and the most advantage of time when there is time to be had. Whereas where I started my career, it wasn't the case, and it was more of an expectation that you had to be there and you always had to be available, and more emphasis was placed on keeping up those sort of appearances, or so one good news is there's been a very much a general trend in the right direction in terms of giving people as much space as the profession allows. Second thing is there is a reality that not every firm is the same on this front, and some firms are more accommodating than other firms. So I've been at two other large national Canadian firms in my career. And so I can tell you at one, I won't say who, but at one, there was a recurrent conversation about whether or not the firm should prohibit people putting on out of office emails. That was literally something that was being debated in the partnership circle, because we don't want our clients to ever think we're not there. Because the scary thing about the legal profession is, there's a lot of good firms out there. And so the reality is that, amongst the top brass, you're always just lawyers are incredibly paranoid people. Or can be. And so you're always afraid that if you can't say yes to a deal, or if you're not the first person to answer that call when the client says, we've got something happening, we need you right away, that they're just going to move on to the next person. So there are some firms who are doing better at this than others. And then frankly, to be completely fair, even within firms, like there's different practice groups, and some of my firms, there was a real distinction between how good the humans were in the corporate group and how good the humans were in the litigation group. And I was happy in the corporate group, but boy, they had trouble retaining people in the litigation group. It's a trickle down effect by the biggest and most influential partners. They kind of set the tone. So you can have different microcosms within a different firm, because it's those rainmakers that often set the tone for their group. So you really have to be. It's just something to appreciate that different firms are going to approach things differently. And even within firms, there can be different approaches to different groups. What you need to try and do is find a group of good people you want to work with and who are on the right side of that ledger when it comes to appreciating that people need time and space to live.
And so I would say and I totally 100% agree with you. And I think the question that comes out of that is like, how do I find these people and how do I find these groups? Because you're sitting here and you're like, I don't know anything about these people. And really it's just by, again, talking to people, asking the questions, going for coffees with individuals and different groups and different lawyers, meeting as many people at the firm as you can to get a sense of what their cultures are like, and not only what the firm culture overall is like, but also the group culture. Because like you said, especially when you look at the big firm scenario, there's going to be, within the big firm, there's the smaller groups. And those smaller groups each have their own cultures within that larger firm culture. And it's that culture that once you're within the firm, those are the cultures that you're going to want to get to know in terms of when you're getting hired back into a particular group, because that's the group that you're going to be, and that's the culture you're going to be within. And having a supportive group culture that recognizes that that you don't exist just only to work, and that you have a life outside of work, is essential to be able to get through it. Because law needs to be sustainable at the end.
The culture aspect is so true. Like we're 3-4 doors down from each other, and the people we interact with on a daily basis is completely different. And the meetings we go to and group culture. Yeah.
Thank you all.
Yes, I had a question regarding like clients, I guess. So is like client acquisition something that is a part of you guys' role, or something that you guys don't really like think about when you work in like a big firm or the big team?
I would say it depends. The classic lawyer answer. It depends on your year of call. It depends on the group that you're practicing within. It depends on the type of industry that you're in. So, for example, when you're a junior, you're not expected to go out and beg like $1 million client. Like that's when you're a junior, especially within your first like 1 to 3 years of call, you're really there to submit your skills. Like you're focusing on skill development, getting your foundations down, that sort of thing. You're not there for client acquisition. Client acquisition doesn't come in until you're far more either like senior associate level or like partner level. If you get clients in when you're a junior, great. I don't think any firm's going to turn them down, but it's not an expectation by any stretch of the means. And again, it depends on your group. So, for example, if you're in a group like, not like keeping on natural resources, but like if you're in a group where you have like a fewer large clients, then maybe the opportunities for getting a client may not be as much emphasized, right? Because a lot of it will then be succession planning and like staffing out teams that serve those large institutionals that are already from clients in order to retain them as for clients. It's a little bit different for me because so when, for example, in my group, at the tech group, we have many small clients. Like our clients are smaller, and so we have a lot of them, and so we support them because that's what we do, and they're our clients, and we love them. But like we go out and we talk to people, and we talk to companies, and we do try to acquire clients. But again, as a junior, you're not expected to. Like you're not expected to go out and acquire clients. You're expected to go out, just meet people in the community because that's what we do. We go out and we support the tech community and get ourselves out there and just be present and try to educate and try to talk to people, see what's going on, that sort of thing. So it's more education based. But later on, yes, you're going to be expected to bring in people because that's for me, from my group, that's what is the expectations.
Yeah, I'd say as a lawyer on the public side, I probably won't get a TSX company to come in, based on my credentials. You think I can? But then I had friends who might have other legal needs, and I brought in a few clients, but they're just friends, right? So the firm's supportive of that. But then in my group, yeah, it's not really an expectation on the public side, but they do encourage us, to go to networking events and put yourself out there, whether it's, giving presentations, like on an educational front. It's also, enhances like your own brand, whatever shape or form it comes in.
I would say it's really just about building relationships. It's about getting out there, meeting people, building relationships. You never know, you don't have to sign a client right away, right? It's just about getting out there and meeting people and getting to know people, getting to see what they're about, letting them to see what you're about. And then you never can tell what might happen. It might happen tomorrow, it might happen 10 years from now. You can never tell where people are going to end up, and you can never tell what's going to happen in the future. So just about building relationships, getting out there, meeting people, and just becoming friends with people. That's how I view it.
Yeah, I've met, like financial advisors from different events I've gone to, and that's like come into fruition in my practice too. Sometimes clients will ask, "Oh, like, do you know this person?" And then I've been able to put some names forward in that sense. So yeah, building relationships, even if it's not clients, but like other advisors, I probably have met more in that space. But yeah, your biggest clients, like at my stage, are the partners that we work for. So, impressing them and like, when learning from them, it's probably just what my practice looks like right now. Thank you. It's really struggling.
I know, that's why I put my so it's like constantly talking.
Nothing to add. That was great.
Okay, I think we have time for maybe one more question, if there's.
Paul, I know you work at the Calgary location. So working at like a smaller location, do you work with a lot of deals from Toronto or Vancouver?
Yeah, no, I think Calgary is a real sweet spot because of the energy industry. We do a real mix of local, regional, national, and international deals, and I think Vancouver's similar, right? Uh, and they're all different. International deals sound sexy, but when you're getting emails from London and emails from Tokyo and Singapore and Dubai, that means you're getting emails every hour of the day. International deals lose their allure pretty quickly. But yeah, we're lucky in Canada. You know, a good mix of deals. And when you do different deals, you realize that different towns have different cultures. So in a town like Vancouver or Calgary, where it's not a super huge legal community, you're more likely to run into the same lawyers, you know, every now and again. And when you know you're going to have to deal with someone again in the future, or there's a good chance you're going to have to deal with them again in the future, you know, it pays to be reasonable, right? Right? You just want to get the deal across the line. But then you notice when you deal with lawyers from like London or New York, for example, which they just have tens and tens of thousands of M&A lawyers, and the chances that those guys are going to see one another on another deal again are so slight. You know, they handle themselves totally differently, and they're not, you know, yeah. You start to see how different towns and have different lawyer cultures, and some are more agreeable. I'd be interested in Cam and your thoughts on that, having practiced at one of the largest U.S. law firms in New York. But I think the bar in Calgary is pretty reasonable, because it's a small community, and you're likely to see them again or see them at the bar or at the restaurant.
Yeah, I guess I'll just close it out and respond to that real quickly. So, you know, I practice in the United States. I've not practiced in Canada, so I do not have like firsthand experience in Canada. But based on kind of observation and even evidence to a certain extent, I would say that the culture of transactional practice in the U.S. is different, and it's harsher. People are not. I think in Canada, the stereotype is that Canadians are very polite, which I think is true. But I think it's certainly true. Like I've kind of observed negotiations in Canada, and it's friendlier. It's a friendlier tone. People are more agreeable with each other. It doesn't mean that they're not firm on important points. I mean, it doesn't mean that they're not doing a good job representing their clients, but there's just a more kind of a more respectful tone, I would say. And I think in the U.S., lawyers tend to be much more direct in a way that can be less polite and often can be very just frankly hostile. And I think that that's acceptable in the United States. Like you'll deal with lawyers who are just hostile, and you're like, well, not great, but like whatever, just have to deal with this hostile guy. And I think in Canada that would be considered, quite rude and inappropriate. Is sort of my impression. But again, things are different. Like Toronto is probably different than Vancouver, which is probably a bit different than Calgary. And so it's something I mentioned in my study. I mean, it sounds like maybe like, oh, just different people are different, like whatever, just there's cultural differences. But I think it actually matters, because I think to do an effective job for your client, like in the Canadian context, you need to kind of conform to what the professional expectations are. And it's the professional expectations that are people are polite with each other, they're friendly with each other, they press on important points, but they always do it respectfully. And like I think you need to conform to that to be constructive, right? And I think I think if you tried to bring like a really aggressive kind of New York style to a Canadian practice, you probably wouldn't get anywhere, right? And people would not be willing to give you the benefit of the doubt. Like you wouldn't make a lot of progress in your negotiations. Whereas I think if you brought the Canadian approach to the US, people like, you'd get taken advantage of, like you would just get steamrolled, like people just be, very, very direct. And at the law firm I work, like in every law firm is different, right? I worked at a law firm that was sort of notorious for just having the most cutthroat, hostile culture imaginable, like even in the US. And it was, quite bad. And that, I mean, I didn't say, I'm not going to say I had a bad experience necessarily, but that aspect of it was like quite striking for me as a young person. And there's other firms in the US that are not like that are totally different. So, and just last thing I'll say, and then we need to shut it down. But I also agree with Paul, what you said. Just for those of you who are thinking about working at big firms, it is important, although difficult, to figure out like who you vibe with at the firm, because different practice groups are different. And frankly, like even different sort of like partner silos are going to be different, right? So like, you know, like partners, they tend to work with like the same teams of people, and just those teams, even when they're practice group, will be different. They'll have different cultures. And so I totally agree with what Paul said about that. Anyways, we do have another class that's going to come in pretty soon. So we unfortunately have to end it. Let's give another round of applause to our 3 presenters. And thank you all so much.